I'm assuming you can all see the slides. There's not put something in the messaging, and we'll do something about it. And just so you know, this is being recorded. So I'm a lawyer. I got my own practice called Clearview Legal. If you look it up, it's there. You can find me on LinkedIn as well. And this talk is about using AI in business. What are the legal risks? And if you're really interested in AI and legal stuff, I've got a weekly LinkedIn newsletter. It's quite hard to find on LinkedIn. So if you're really interested, drop me a message and I'll see if I can add you to the list or let you know how to subscribe. So the talk is about AI, and I am going to hold on a minute, break that down into three kind of main topics. One is use scenarios, not use cases, but use scenarios. You'll see why. I'll talk a bit about that. I'll be quite brief. Then I'll talk about regulation, which is important in this context, and then I'll also talk about the issues. Now, you don't have to wait to the end to ask me any questions. Feel free to ask them as you go along. Equally, if I'm mumbling or talking too fast, just let me know. That's fine. I may not be able to spot everything in the chat, but someone will, and will let me know. And I'm just looking at the chat. There's meshes there.
All okay. It's me sharing stuff.
Okay,
so
that's fine.
I'll interrupt you, Mark, if there's something really important.
That's fine.
Thanks,
Okay,
Mark.
so no problem. So use scenarios, and it's important because, sorry, wrong way down. Sorry, I've gone right to the end now. Just hold on. Some mismanagement of the keyboard. Right, because there's lots of different ways you can use AI. So off-the-shelf ChatGPT, you can have your own chatbot or whatever powered by, for example, ChatGPT. You can have your own LLM. You can have your own instance of LLM plus your own training data. And those various scenarios, and I can't cover all of them. I'm not going to talk about all of them. I'm going to talk about the generality. I'm not going to talk about licensing terms of LLM or licensing in data or licensing out your own training data, whichever. So just bear that in mind. And also, the risk profile changes substantially if it's an internal facing LLM, which your customers never see, or if it's a customer facing LLM, which your customers see and use. Your risk profile changes, obviously. And also B2C and B2B. B2C, business to consumers, consumers are much more protected than business people. If you're B2B, the law's working assumption is you know what you do, you can look after yourself. If it's B2C, then the law's working assumption is they'll protect the consumer. So bear that in mind. Then regulation, and I'm talking primarily kind of briefly about the EU Act because it is relevant, and then also about the UK GDPR for reasons which come evidence I can go along. Now, there's been a lot of talk about the EU Act, a lot about it in the press, and you may think, well, it's got nothing to do with me. It's coming to force about 2 years from now, but in a staggered way. But it will have something to do in a number of ways, at least 3 ways. One, it's probably going to become the gold standard for this kind of regulation, a bit like GDPR is. If you're putting your product on the market in Europe, it'll definitely apply to you. And it also has an extraterritorial effect. And here's what it actually says. A provider is someone who puts the LLM on the market, the AI on the market, under their own name. So if you take ChatGPT and put it under your own name as a chatbot, then you become a provider. And a deployer is someone who makes the AI available in its own business, effectively, or to its customers. And here you can see, if you look at the bit I've highlighted, that if the output is used in the union, then it's subject to the EU AI Act. So even if you're the UK, which is, as we think all now know, is not part of the European Union anymore, if you've got output from LLM being used in the Union, then it's subject to the EU Act, the AI Act. Now, what does output mean in the practice? What does use mean in practice? Well, you can imagine lots of different scenarios. I looked at something, did I use it? Don't know, does it apply? So there's going to be a lot of uncertainty in my view about this, and frankly I can't see how anyone is going to enforce it in the European Union unless you're a huge company like, I don't know, a very large company and you've got a lot of impact in the European Union. But it's worth bearing in mind that that is there and it can apply. Right, then I'm going to talk a bit about the GDPR, and if you just hold on a minute. Well, I'm talking about the two of them actually. Now, if you've followed the AI Act stuff at all, you'll know that actually it's quite a different piece of legislation to what compared to, for example, the GDPR. The GDPR is primarily about giving rights to individuals. The EU AI Act is about product safety. So if you imagine lifts, things like lifts, medical devices, you can't put them on the market unless they've got a CE marking. They're certified as being suitable, meeting the standards, so you can put them on the market. That's exactly what the AI Act does. It's saying actually this bit of AI has been certified, meets safety criteria, and can be placed on the market. It's essentially about product safety. Whereas the GDPR is, as I said before, primarily about consumer rights, individual rights. Now, the UK government has taken the decision that we're not having our own AI Act in the UK, and all the regulators have been left to kind of sort themselves out and propose and bring in their own regulations. And you might think that that means that the UK doesn't have much legislation governing AI. But that's a mistake, because the primary use for AI will typically be manipulating personal data. That's what you can be. Most people, 98% of uses of AI will be about data which is personal or treated as personal by the GDPR. So the AI Act, the UK GDPR is wrong way again, is relevant. And it's important to bear in mind that it's really quite suited to it because it's technology agnostic. It doesn't care whether your systems you're using are AI or not, and it's based on principles. So it's really easy to adapt it for an AI world. So the basic principles, to summarize them there, are it's got to be lawful, it's got to be fair, it's got to be transparent, it's got to be accurate, it's got to be purpose limited, and it's got to be purpose proportionate. Maybe that should be proportional. So here's a kind of typical breakdown of fair and transparent. So fair meets reasonable expectations of individuals, no unjustified adverse effects. But you can see how easily you can build that out into no bias in the training data, no bias in the algorithm, and all the ethical standards you hear discussed about AI fit very easily into the GDPR. Okay, just kind of natural fit. And all the stuff about explainability and so on, right? Here's what GDPR expects from you: transparent, clear, open, honest. Fits very easily. So this kind of working assumption that a lot of us have or have had that actually the UK doesn't have AI specific legislation is a bit misleading, because in 98% of the cases you're going to have the GDPR, and that will apply. And I hope that makes sense. Now, within the GDPR itself, and just bear in mind, we have two GDPRs now. We've got the European one and we've got the UK version, and slight divergence, but more or less identical. But within them, there is some stuff which is specifically kind of designed for AI, is and isn't. And that's to do with automatic decision making. So one of the things you don't have to use AI automated decision making. You can use any non-AI systems, non-AI software to do it. But AI is the kind of stuff you might particularly want to use for um, for that. And the automatic decision making applies in a number of stages, and GDPR applies a number of stages to you. So if you're all the distinctions between controller, processor, all that kind of stuff will apply equally in an AI context as in a non-AI context. One of the first things you have to do if automatic decision making, if you're using it, is disclose it in your privacy policy. Okay, and here's the extract from the GDPR, right, which you may have seen before, not seen before, but it will apply. You've got to be transparent and disclose to people that you're using it and the logic involved and significance and the impact of doing that. That needs ought to be in the privacy policy. And then there's automatic decision making. When you actually start using it, it's constrained. Now this is the actual wording again. The wording begins very oddly. I think the data subject shall have the right not to be subject. Basically means you, the controller, can't do automated decision making unless, right? So if it's solely, if you don't have human intervention, then this applies. If you have human intervention, provided it's meaningful and credible, this doesn't apply. Equally, this prohibition applies if it has legal effects or things which are akin to legal, similarly significant is the phrase. And the typical ones are kind of credit scoring. That is typically that's seen, job applications, credit scoring, that kind of stuff are typically seen as having the right kind of effect. So if it's that kind of thing, you can only use it in two circumstances. There's explicit consent. You actually get someone to say, I agree to that you can use automatic decision making in relation to me in this context, or it's necessary for entering into or performance of a contract. Now, I've never the first one, contractual necessity, I've never quite understood. I don't see how it could ever be necessary for it, but that may be wrong. There may be use cases will turn up and say, yeah, for that situation, it's justified. But even if you go down these two routes, you have to offer, and this comes back to explainability. And this is in the AI Act as well, slightly different phrase slightly differently. The right to obtain human intervention, right? The right to, I want to talk to someone about this. You can't just foist it on me. The right to express your point of view. I don't agree. This seems to be wrong. And the right to contest the decision. And you'll see earlier, all that will involve explaining the logic of the decision as well. So all that stuff is already in there, and that will regulate AI systems just as it regulates non-AI systems. Now, let me just check, I've got some notes. Now, there've been a couple of decisions involving this kind of stuff in one Holland, one in the Netherlands. So that's the EU GDPR. For these purposes, it's all going to be the same. One involved Uber, and the other one involved Schufa, which is a credit scoring company and a lender. And in the Uber one, Uber fired, well, it fired people in a slightly odd way. It just deactivated the account of the number of drivers because they thought they're being fraudulent. And this is what happened. The fine mounted up because Uber was supposed to disclose some information which it didn't. And it was the fines accruing at 4,000 euros a day. So it started off quite high and then accrued. And you can see the things. So Uber deactivated their accounts, didn't give an explanation. So drivers were out of work or couldn't work for Uber. The Dutch court, you've got to provide meaningful information so the workers can challenge your decisions, right? And also, the Uber's human review was a symbolic act. It wasn't meaningful. So the court just said, no, that doesn't count. Also, interestingly, it's not on this slide, but Uber said, we don't want to reveal the meaningful logic because that's a trade secret. But the court said, well, that's tough. If you're firing people using logic, using automated logic, you need to be willing to reveal that, otherwise don't use it. And then the next one, that was in 23, and this one I think is this year, Schufa, as a credit scoring company. Now, Schufa's a credit scoring company, a bit like Experian, one of those. They then said, this person's got this credit score. They pass it on to the lender, a bank, and the bank would say, actually, your credit score's too low, we're not lending. It got challenged. It went to the European Court of Justice, and they said, well, actually, the fact the bank is taking the decision, we don't care. We're going to look at it as one. It is a automated decision, therefore is subject to the GDPR. Clearly, it's credit scoring. You don't get a loan if you don't pass. It's got significant effects. And the fact that the original credit scoring company didn't see itself as a decision maker didn't count. Interestingly, again, Schufa, the credit scorer, said, we don't want to disclose the logic because that reveals our trade secrets. And the court said, no, doesn't work. If you're choosing to fire people, if you're choosing to make an automated decision on this basis, then you had to be willing to disclose it. So that's all just GDPR. This is all kind of old law, really, but will apply to very large proportion of anybody's use of AI. Of course, if you don't want the GDPR to apply and you've got personal data and you want to do some analysis of it or do processing of it without GDPR applying, the answer is anonymize the data. No longer personal at that point, and GDPR falls outside the GDPR. So, still on GDPR though, the ICO's view is that says all AI, but nearly all AI here will be high risk, and therefore you've got to carry out a data protection impact assessment before you deploy it. Okay, and that's not too burdensome, and that's probably good practice anyway, certainly in the early stages of AI, while we're all trying to figure out exactly what it is and what it does. And more than any other kind of system that processes data, the ongoing governance is going to be pretty important because there's model drift. The model drift, which means you need to be reviewing what the model's doing. You need to be reviewing the decisions to see if they're fair or not fair, if there's any drift in the decisions. And kind of, I've overstated it slightly because the ICO doesn't expect every system to be perfect, but a lack of accuracy, apart from being dependent on what you mean accuracy in this context, but it kind of is quite close to becoming unfairness. And the other important thing is this. The deployment, I'll read this out, it's quite important. The deployment of AI system to process personal data needs to be driven by evidence that there is a problem. So you do need some kind of fix and a reasoned argument AI is a sensible solution to that problem. And the fact that AI is just available and is kind of the latest fad, if that's the right word, isn't enough to justify using AI. So the key questions before you deploy the AI, and this is what part that the DPA is all about, is AI the right technology, and is there a less intrusive solution? And there's a good parallel for this recently. So you're probably all familiar with a company called Serco, which was a kind of big outsourcing company back in the day. It's still around. Apologies, anybody's from Serco on the call. It's not quite as prominent as it used to be, but it was monitoring. It was in charge of running about 38 kind of community stroke leisure centres around the country. Serco had problems with timekeeping of its staff, and the staff were kind of clocking each other in and maybe actually sharing things for clocking in and out, all that kind of stuff. So it knew its timekeeping was not optimal. So basically, it switched to a facial recognition technology solution and fingerprint technology. So as you went in, your face would be scanned and your fingerprint would be scanned, and that's what it defaulted to. I can't remember how, but it ended up with the ICO, and the ICO's conclusion was basically the use of this non-AI, but still biometric technology was not justified. It was too intrusive, and Serco did not fully consider the risks. They did not do a proper DPIA before they deployed it. Now, what does it mean by intrusive? It's quite interesting. What they say was, if you've got a normal password, you can change it, but you can't change what your face looks like. Now, it's slightly odd reasoning, I think, because actually the whole point of facial recognition technology is you can't change what your face looks like. That's the whole point of it. But what they kind of said, what the ICO kind of said, well, if there's a leak of this biometric data, what your face looks like, what your fingerprint looks like, that's a bigger risk for you, or a bigger risk for the individual, for the data subject, for the worker in this context. Now, I find that reasoning slightly, you kind of get it, but it's slightly odd. But I think that the real, where Serco really fell down is they didn't do a proper analysis beforehand. A lot of regulators, what they really cannot stand is people who don't take the regulation seriously. If you take it seriously, show you've taken it seriously and get it wrong, they can live with that. But what really gets their goat is when you don't take it seriously. And that's what it means that Serco did not fully consider the risks. It just prioritized, it just assumed that its business interest overruled the interest of its employers' privacy. And it kind of, the ICO objected to that on principle. If Serco had gone about it the right way, then they probably would have got away with it. It would have been so much of a problem. And one of the things, maybe offer alternatives to do a proper assessment, see what the risks are, upside, downside, offer alternatives to employees, and then you have a then you have a much more defensible, proportionate case which you can justify. So that ends the bit which is about the GDPR and how kind of GDPR is the primary piece of legislation that will that will kind of control how we use AI in this country. And I should point out that it still applies in the European Union as well. The AI Act doesn't replace GDPR; they both apply at the same time. They've got slightly different. Well, they've got pretty different functions. There's a bit of overlap, but not too much. So risks and issues. Here's what I'm going to be talking about. What happens if the AI gets it wrong? Who owns the output? Copyright infringement, bias, and then a bit about, depending if there's kind of interest and time, data, web scraping, and confidentiality, and use of your information. Again, if you've got questions, please feel free to shoot them out, put them on the chat. So, first question: who's to blame if AI gets it wrong? And I'm talking here primarily customer facing gets it wrong for the customer. And of course, there's a big distinction I mentioned earlier between B2B and B2C. And let's look at, there has been a B2B decision, B2C decision in Australia to do with an airline which was trying a chatbot. And here's what happened. Air Canada, in case you ever fly Air Canada, the customer didn't understand how the pricing was supposed to work. I can sympathize with that. It was some refund system. Asked a chatbot. The chatbot gave an answer. The customer relied on the chatbot's answer. Chatbot was wrong, and Air Canada refused to pay on that basis because they said that actually, well, there are two arguments. Well, the first one was so weak, but they said that the chatbot's answer said, and here's the relevant piece of gave the wrong answer, said here's the relevant URL to see what the policy actually says. And the Civil Resolution Tribunal in Canada said, yeah, tough, right? You said it was X, therefore you're stuck with X, and you can't say to people that they can't trust one part of your website, including its chatbot, and therefore have to keep checking it against the other chatbot. And that, I think, will be the answer in just about every consumer-facing piece of AI gets it wrong in the UK. because, as I said, the law is very protective of consumers, and if a company deciding to use AI-powered chatbot or just AI generally because it saves it costs or whatever, then they've got to take the consequences of that and make sure that the AI is doing a proper job, and if it's not paying a proper job, then they'll have to suffer the consequences. And you as a business may take a view, well, actually, you could afford to take a couple of hits, provided the overall cost, both in terms of money and in terms of reputation, justifies it. If it's B2B, then I think it's different. Then if B2B, I think it's much easier to say, yeah, well, you, Mr. Customer, getting the cost benefit of this AI-powered system. You're getting the cost benefit. You know that AI can be a bit erratic. Therefore, take it all with a pinch of salt, and you should check it yourself. And everyone knows that AIs hallucinate. Someone described to me the other day, everything that AI system produces is a hallucination. What's actually surprising is how accurate some of its hallucinations are. And I think that's a good way of looking at it. So B2C chatbot B2C is high risk if you provide information which will have an effect on people. They can come back to you with that. B2C, so B2B, less risk. Next question would be, who owns the output? And do you care? Why should you care? When should you care? So let's say you're now using, or your business is using AI a lot, puts in a prompt, gets the output, then who's gonna, who who owns the output, and do you care? And there's a big difference here in my view, and let me come to it a bit later, between something which has got a transient use. For example, you're doing a presentation in 2 weeks' time and you get AI to knock out the presentation for you, or it's something which is an inherent part of business, actually part of business itself, like some kind of policy maybe or something like that, or even more so, it's part of your business product, if it's software, for example. And in case you're wondering, who owns the output one? This is what ChatGPT says, what OpenAI says more accurately. It says, as between you and them, you own it. To the extent we have, and this wording, as between you and OpenAI, I come to why it's worded like that. We hereby assign to you all right or interest, if any, again, to the output. That's what OpenAI says. I haven't reviewed all of them. The next one I took a look at. I took a few of them, but it takes too much time to go through all of them. Microsoft says quite more the same thing, but not quite as clearly as OpenAI. Microsoft does not claim ownership of prompts creation. So that's your output, blah, 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 blah. Okay, it doesn't own it, doesn't claim ownership, but actually it's got this cheeky bit at the end. They can do whatever they want with whatever you've produced, whatever the output is, which I think frankly is a bit rich. One of the difficulties looking at this kind of stuff, just bear in mind, is if you try and look at Microsoft terms and conditions, there's about 53 different documents all linking one to the other. So trying to make sense of it is actually pretty hard. And it's probably designed to be that way. But there's a more fundamental question than that, which comes to and explains the ChatGPT wording, and it's this. UK is the only country that recognizes copyright computer-generated works. Okay. In the rest of the Europe, in the US, if it hasn't been created by a human, it's not a copyright work. And frankly, I think that's total nonsense. But there's a lot of history behind that conclusion. And that's the present state of the law in most parts of the world, except for the UK and other territories I'm not aware of. But certainly US and the European Union, if it's computer generated, there's no copyright in it. Now, why do you care? Well, you will care because if, for example, you're using an AI generate code for you for your AI product, for your software product, and it does creates a lot of code, you will have a lot of code which you don't own. And no one owns it. It can't be owned, which is why OpenAI phrased it like that. As between you and me, you own it. Any copyright, any right, if any, you can have them. But according to most copyright law around the world, if it's generated by a AI machine, it's not owned. And that makes a difference. If your business is creating software and you are using a lot of AI to create the software and you want to sell your business, and main product is business software, and a buyer or buyers come do the due diligence and see that actually no one owns this stuff, you won't get the full rate as if you had paid for it, created it, or as if you did own the copyright. And that's just a fact of law because they can't defend it. If some, so can I can't mute everybody, but if someone could mute, that'd be good.
Fine, I'm doing it. Don't worry.
Thank you. Yeah, so that's a big deal. So you can't sue. If someone rips off your copyright, the first thing you have to show is that you own it. And if it's AI generated, you won't own it. Therefore, you can't sue for copyright infringement. So that's a potentially big deal. Next one. Hold on. What's my exposure to copyright infringement? How big a risk is it for me? Now, that's a big topic at the moment. I don't know if you follow this stuff, but New York Times sued OpenAI because it claimed OpenAI basically web scraped loads of stuff, including all New York Times 200 years worth of publications, because New York Times is seen as a good source of, data, writing, all that kind of stuff. So it scraped it for it, and New York Times could actually, by putting the right prompts, actually get OpenAI or ChatGPT to spit out verbatim, 300 words at a time, 400 words at a time of New York Times articles. Sony recently sent a letter to 700, I didn't realize it was 700 producers of AI systems, saying you guys have scraped and Sony owns a lot of music. You have scraped our music unlawfully. We're coming after you. And there's also Getty Images got scraped by Stability AI, and it's suing them in the UK. And is a good example. The one on the left is the original Getty image, and this is the prompt would have been produce two footballers playing, I don't know, maybe Spurs playing Liverpool, background, and this one on the right is what it produced. So interestingly, you can see it's got the Getty Images logo on the right hand side, kind of slightly blurred, reduce it 100%. And what is kind of you can see it's a Spurs shirt actually, just about, by the kind of logo in the top right. But what was AIA has now become AA, and so on. So there's a lot of claims going out now. In the US, it's going to turn around things like fair use. Is this a fair use of someone else's copyright works? In the UK, it won't, because we don't have fair use. We've got fair dealing, which is much more specific. But it's an issue that's reverberating around the world. And in the UK, and in Europe, there's a prohibition on text and data mining in most commercial circumstances that will affect it as well. The Google and copyright and all the other big providers have kind of reacted to this by saying, don't worry, we will indemnify you if you get sued as a result of using our product. Now, they've given indemnities. Those indemnities are subject to caveats, that you don't input copyright infringing work, obviously, various things like that. But how much is the indemnity worth to you? So this is Microsoft's indemnity. You've got various options, but at its option, they'll just give you your fees back, right? So whatever you paid, you get back. So you may be sued, in theory for millions or hundreds of thousands, but you get your fees back. So totally worthless, to be blunt. But more fundamentally, I would say, are you at risk from this? And I'd say no. I mean, if you input infringing, if you input someone else's copyright work, then you're at risk. But if you just use it and it, produces something for you, which is an infringement of someone else's copyright work, are you at risk? No, not because you're not infringing, because you probably are, but they won't know and they won't have time to sue you. They're too busy suing people like with the big pockets like Microsoft and OpenAI and so forth. So my view is relatively low risk for most users, that is. Then, what's my exposure to claims of bias and discrimination? So this isn't particularly AI specific, as this example shows, but this is one from 1988. And there's plenty of other more recent examples showing that AI will reproduce their biases, which exist in the data it is trained on. And since we know that there are quite a lot of biases in our society as well at present, you have to assume there's biases in the training data, and therefore the whole doesn't mean you can't use it, but it means you have to be aware of it, recognize it, adjust for it, and your governance needs to be able to keep an eye on it and make sure it doesn't get out of hand. So this will not only be an issue in terms of GDPR, because it's unfair, it also be issued in terms of Equality Act and discrimination, because Equality Act discriminates between, well, both are discriminatory, intentional discrimination and unintentional discrimination. So if you're using LLM, which has a built-in bias and which you don't know about, but it still is a bias and it treats and discriminates against people, then you're liable under the Equality Act for that, and fines are unlimited. Now, most fines aren't particularly big, actually. Well, not in the grand scheme of things. Anything from 30,000 to 50,000. That the outliers hit, 2.5 million, 4.5 million in really extreme circumstances. So that is an exposure we're all going to have from using AI and making decisions about people. Then the last three, I'm going to skate through very quickly. Ownership of data. Yeah, I mean, ownership of data is a bit of a fraught subject. Assuming it's your data, you can own it. But we're now subject to the database right, which assumes you only get to protect that data, only get the database right if you've put a substantial investment in the development of that data. And that's undefined, so that's a bit of an uncertainty. And if your data is a byproduct of something else, then you won't have your database right to protect it. Classic example is if you're a football league and you organize all the teams, and Sheffield Wednesday is playing Manchester United on Tuesday at Old Trafford at this time, and you create that whole compilation to become a database. That database is presently not protected by the database right because it's a byproduct of the main activity. Total nonsense in my view, but that's the law as it stands. Web scraping. There are prohibitions on text and data mining in the UK, subject to various caveats, and that's just for copyright kind of protection. And web scraping raises GDPR issues as well, because you don't have a relationship with whatever it is you're scraping. And so all you can defend, the only lawful basis you have is legitimate interest, and therefore then you have to decide what are you being proportionate and all that kind of stuff. So it's possible to do it. You'll be slightly careful about how you go about it. And confidentiality, I'm not going to talk about it much, but when you put a prompt or you submit data which you want the AI to look at, does that data stay confidential to you, or is it then used as training data? And it could appear unlikely to, but it could appear somewhere else. Now, most I think OpenAI and Microsoft, Google as well, give you an option as to whether that data can be reused or not. But whichever of the 700 AI providers you're using is something you should check before you do that, before you use them, or just use them for data where you don't care if it gets reshared. And that brings me to the end of that. So I hope that's helpful. If you've got any questions, then please feel free to put them in the chat or raise your hand or whatever most easiest for you to do.
There's nothing in the chat at the moment. I did put a message, Mark, about if people have specific examples or questions related to their businesses. So if anyone wants to put their hand up or anything, that'd be great.
Don't be shy. I mean, are you, Sarah, for example, are you using AI at the moment in your business?
Yeah, it varies. So probably one of the sort of questions, and I was at the AI event last week, which was a face-to-face event. One of the biggest questions is the security of the data and what the data is being used for. So, I mean, I'm a business psychologist. We make a lot of decisions based on lots of data, whether it's measuring culture, whether it's personality profiles, whether it's competency profiles. There's lots of different elements. And my concern is that some decisions are not, I don't know, right or wrong or yes or no. And AI, as you said, it's learning all the time. So it's always going to be a bit different. So I'm worried about the ethics of it, sort of, I suppose, like you say, there's some decisions out there that are not being sense checked and are actually having very negative impacts on people. For example, Uber getting rid of a load of employees. And actually the impact, the psychological impact on people can be horrific with some of this stuff, just as being taken to court for a breach of something. So I mean, what advice have you got? If you could say one thing to everyone sort of about what they could do as an SME, a small company, what would you recommend?
That is a very good question. Well, there's a number of topics, right? So on security, you've got to have good security nowadays because a data breach is it can be incredibly expensive to remedy.
Yeah.
And because you have to buy, for whatever reason, in fact, the talk remit data breach was, I know, 6 years ago. It cost so much that changed the way the insurance industry approaches insurance. That's the first point. I think the other point is this governance that do not assume that the AI knows what it's doing. The AI has no idea what it's doing. I mean, to be blunt, it doesn't know. It's working. It's rolling the dice each time, and that applies to if you're using AI for business. It's not like normal software where if you put the same input each time, you get the same answer. AI, the answer will change from day to day. Therefore, the governance thing is quite important. And of course, the more sensitive and important and impactful the data is, the tighter your governance has to be. Now, it's amazingly easy to get AI to hallucinate. I want to do a bit of reach out marketing to some people, some CEOs, and I had their name, their job title, and the company they work for, 10 of them. I put it into ChatGPT and I said, please get me the LinkedIn profiles for these people. 15 seconds later, there it was. I thought, brilliant. I thought I better check them, and I think one was correct, and that was clear. It just made them up. So, and there's no way it will. The AIs, their cutoff date is usually some time back, so they don't naturally have access to
I was going to say it's quite old, isn't it? You're right. As you sort of see it on a lot of it, it says, only using data up until 2000 or 2021, and obviously a lot of things have changed in that time.
Yeah, I mean they're changing that all the time, but they're updating all the time, and there's ways to fix that. You have it's called RAG, something augmented data, but basically, if you've got your own version of it, if you're using, I know, ChatGPT as the core, but your own instance of it, then you can get it to go and pull more recent data or look at specific data that you have and match it with that. There's ways to fix it or ways to mitigate the risk would be a better way of putting it.
It's interesting. One of the things that was said at the event last week, which was sort of quite well, it was very well attended, but there were lots of questions. Was and I think it was someone from Deloitte who said AI is like a teenager. It's 100% confident it's correct, yet actually it's only correct about 70% of the time. And that really resonated, particularly with what you're saying about the hallucinations and that belief that people have in whatever it is they read being actually true rather than evidence-based and based on fact.
Well,
Right.
one of the shorthands I've read is when to use AI. A, when it can do it faster than you, and B, when you can check it, right? If those two things don't apply, then probably shouldn't be using it.
Yes, yeah, which is interesting because with robots, isn't it? If it's something that's dangerous, if it's something that's dirty, if it's something that, is sort of can be duplicated and stuff, there's a load of sort of, reasons why you'd use a robot. And I think with AI, everyone's trying to use it for anything rather than going, do you know what, actually, it could save us time in this. Right, come on, there's some more people on this call because I can see. So we need some other questions. If not, we've got Nigel. Right, Nigel's put his hand up. Over to you, Nigel.
Hello, can you hear me?
Yes, I can hear you.
Brilliant, brilliant. Thank you very much, Sarah. So I just wanted to ask, I use quite a bit of AI. I'm in recruitment, but I also run a small consulting business. With regards to, let's say, generative AI, I use that mostly for my consulting business. If I'm writing long pieces of text, like business plans and things like that. Now, at times, what I do is I try and take out any personal details of the company or anything like that, and just put like company name in between, so that it's like I forgot what the word is.
We get it. We get it.
Yeah, like a variable. But I find that if I write something which is pretty decent-ish to read and I put it on the AI, it makes it way more professional than I would probably be able to put it forward. Now, I've heard what you were speaking about, the security and that. Now, what would be my implications in that sort of situation if I write maybe 1,000-word document and then I put it on AI and it makes it 2,000 or 2,500 words, which is obviously quite a bit of contribution from AI? What would be, what kind of implications can I look at in terms of security, and also turning around and saying, I own that data. That's my piece of work.
Well, I think I wouldn't worry too much about the security because you're not putting the company name out. I mean, it'd be slightly different if it was. First of all, you check the T's and C's and say, check the T's and C's. First of all, check the T's and C's. Can they reuse your data as training data? Right. First question, either they can or they can't. And you probably want to disable it. Right, first point. Second point, I wouldn't worry too much about security if you're using a fictitious name, right? You don't have, you just put company in whatever, and that will just do it. So that point of view, it's fine. The exception might be if you have something which is so distinctive, it could only be something else, right? Which is pretty unlikely. I can't think of a good example. Maybe if you were Rishi Sunak and only using kind of secret MI5 data, that can only be you. But let's hope he's not doing that. And then in terms of your ownership, for this kind of stuff, I wouldn't worry too much. I was about to say, because this is a one-off proposal, right? I mean, you might reusing the proposal again, but people, and it might get out there, but that kind of thing as a practical thing doesn't. Let me put it this way: the upside you get from using the data, the AI, the upside, which is this, the speed and the quality you get, compared to not using it, I would think outweighs the risk you're going to have of someone ripping off your proposal and using it for some other proposal. Okay. So that kind of stuff I would be relaxed about. It's more if you doing things that which goes into, so because the proposal is only the step to the product, right? And then the service and so on. I'd be more concerned about if you developed a tool using AI, a bit of software, for example, and then you can assert ownership because it'd be generated by an AI, and therefore there was no copyright other than in the UK. That'd be a bit more of an issue. So the test in UK is who owns, if it's computer generated, who owns the output, the copyright with the output? And the answer is the person responsible for putting the computer arrangements in place or something like that, which is a bit vague because I always assumed that, the person doing it would be the person with the computer. But I think you can assume, for the sake of argument, that in the UK you will end up being the copyright owner. But another example, if you were doing an illustrated book, okay, so you wrote the text for sake of argument, but you got all the illustrations produced by AI, okay, then that might be problematic going forward if people started copying it, because you'd say someone's copied my illustrations, and they'd say, well, they're not, you don't own them, and they'd be correct. So you can't complain about copyright infringement in that context. So it depends a bit. Generally speaking, the question is it something you're going to reuse as a product, or something to be either transient use in 3 months, like a presentation, 3 months you don't care, or a private use, which is just going to 1 or 2 selected clients.
Thank you. The second part of it was, in recruitment, I use not ChatGPT. I use some tools. One of them is my application tracking system, which is my CRM for finding candidates. Now, what that software does, it sources data from so many different sources and brings it in. So if I'm looking for, a certain person with a certain set of skills, I can use that to source them. And that goes into LinkedIn, and it goes into all these other sources. And I'm sure they have agreements in place, but how do I make sure that, I've sourced 100 candidates and I'm not breaking GDPR by now having their data in my, local space in that CRM?
Well, I've got 1 or 2 clients, recruitment agencies, and you're not the only one with that problem, right? It's pretty standard for even if even if the guy sends you your CV, you'll generally amplify it by getting more data about that person from somewhere else, right? And everybody's doing that. Now, the Dutch ICO equivalent came out the other day and said nearly all web scraping is illegal. I'm not convinced that's the case. I think because actually when people put their data on LinkedIn, it's right. Let me rephrase that. It's not because something's been made publicly available that you can do what you want with it. Okay. But, so, if I put a film on YouTube or something, or even something else, I mean, you can do what you want with that film. That, as a general statement, that's correct. But if people put stuff on LinkedIn, the general idea is that they want that to be seen by other people. And I think you would probably have a legitimate interest in pursuing that kind of stuff. Now, at that point, what you're supposed to do is notify people. So the GDPR's got two things, right? If you get the data directly from someone, that's privacy policy, they know. If you get it from a third party, then you're supposed to go and tell these data subjects that you've got this information about them from a third party, except if it's too much hard work to do it. And I think you typically fall in the too much hard work category. it's a bit of a grey area that you're, to be frankly, Nigel, I don't think you're big enough to, unless I'm misunderstanding. I wouldn't worry about it too much. You will not be the test case. They'll pick some large recruitment company and make a test case out of them, and then everyone else will fall into line.
Thank you. Thank you. I appreciate that.
No, pleasure. Okay, I think we're coming to end of time. I think if people, there's a couple of podcasts worth listening to. One is very much in the detail. It's called Last Week in AI, and it's exactly that. But it goes through technical stuff, new releases, all the way to kind of policy, and it kind of breaks it down so you can see which one, if you're only interested in one section, you can skip the other section. Last Week in AI. There's also a guy, he's a New York Times columnist called Ezra Klein. He's got a podcast called The Ezra Klein Show, I think. And he did a recent series of 3 discussions about AI and the use and that kind of stuff. And that's quite useful. It's an easy listen. The last one is an interview with the guy who was head of either some CTO at OpenAI or CTO at Google DeepMind or something, and this other guy heads up Anthropic. So if you're interested in that kind of stuff, I'll check out the Ezra Klein one, and that's kind of an easy listen and quite useful in terms of how to approach AI, what it's good for, that kind of stuff. But if there's no more questions, and I think we're coming to time, and we know everyone's busy,
Perfect.
then if it's all right with you, Sarah.
Yeah, no, that's brilliant. There's no other questions. We've got a few thank you very muches coming in. So yeah, thank you very much. I put the link into yourself and the LinkedIn chat and your newsletter. So thank you ever so much for giving us your time, Mark. And thank you to everyone for attending.
Okay, pleasure. Bye.
Bye. Bye.